The right to vote is the most fundamental right of citizenship in our democracy. It's the base where it all starts and it's where it happens. Yet for most of our nation's history, too many of our citizens have been denied that right to vote. For over a century, women were denied the right to vote. And for a century and a half, African Americans were the most brutally attacked with denying their rights to votes, especially in the Deep South. On August 6th of 1965, our nation took a momentous step towards correcting that injustice when President Lyndon Johnson signed into law the Voting Rights Act. That was a result of years of efforts by the civil rights movement led by heroes like our colleague, Representative John Lewis, and Dr. Martin Luther King and others to get Congress to act on protecting voting rights for African Americans. I fear, however, the developments of the last several years have undermined the Act's basic protections. That's because 6 years ago today in Shelby County v. Holder, the Supreme Court effectively suspended the Act's Section 5 preclearance requirement by striking down the coverage formula in Section 4 that determined which jurisdictions would be subject to preclearance. In essence, they said not necessarily that those jurisdictions that had been under preclearance had cleaned up their act, but there were other jurisdictions that were maybe equally as bad or had done bad deeds as well. So they let the bad actors out because they thought there were new bad actors, and they kind of opened the door for everybody. Under that preclearance requirement, certain jurisdictions, predominantly in the Deep South, that had a history of discriminatory voting methods, they were required to obtain the approval of the Justice Department or the U.S. District Court for the District of Columbia before any proposed changes to voting practices or procedures could take effect. That preclearance requirement was crucial to vigorous and effective enforcement of the Act's guarantee of equal voting rights. The purpose of this preclearance requirement is to ensure that jurisdictions that are most likely to discriminate against minority voters would bear the burden of proving that any change to their voting laws were not discriminatory, rather than placing the burden of proof on discrimination victims. By placing the burden on jurisdictions with a history of discrimination to prove their innocence, Section 5 rightly prevented potentially discriminatory voting practices from taking effect before they could harm minority voters. And in this way, Section 5 proved to be a significant means of protection for the rights of minority voters. Section 2 of the Voting Rights Act, which prohibits discrimination in voting and remains in effect, is by itself a less effective and significantly more cumbersome and expensive way to enforce the Act. Factors that would dissuade even those with meritorious claims from pursuing enforcement litigation. Most importantly, plaintiffs cannot invoke Section 2 until after an alleged harm has taken place, thereby eroding the effectiveness of the Act, which is to see that the harm doesn't ever take place. The result of these factors would be that many practices and restrictions that undermine equal voting rights will simply go unchallenged because the harm has been done. These are reasons why Congress had repeatedly reauthorized Section 5 on an overwhelmingly bipartisan basis. Most recently in 2006, when the House passed the VRA by a vote of 390 to 33 and the Senate 98 to 0. So at this time, it wasn't Congress's fault, we were good. Incredibly, the court's majority in Shelby County claimed that there was no evidence to support Congress's findings of continued discrimination voting in the then covered jurisdictions, notwithstanding thousands of pages of record evidence compiled by this subcommittee in 2006, this subcommittee then in Republican hands, demonstrating the continuing need for this coverage formula. Tellingly, events since the Shelby County decision have proved how wrong the court was at its conclusion. Within hours of the decision, states like Texas and North Carolina that have been the subject of the Act's preclearance requirement announced their intention to impose strict voting identification requirements. Other states that had also been subject to preclearance also wasted no time in pursuing voting restrictions that once again threatened to undermine the minority of voting rights, including practices like the restriction or elimination of early voting or same-day registration and bans on ex-offenders from voting, all of which make it disproportionately harder for racial and ethnic minorities to vote. It has a disparate impact against black voters, African-American voters. Last year's Georgia governor's race brought into full view the range of voter suppression practices in formerly covered jurisdictions that may look subtle when viewed in isolation, but are pernicious and devastating in their cumulative effect. As Ms. Stacey Adams, one of our witnesses, the Democratic nominee for governor of Georgia in that race, knows from personal experience, her opponent, Brian Kemp, then the Georgia Secretary of State, embarked on what were a series of seemingly naked attempts to shrink the electorate, which was the job of the Secretary of State on those laws, but he chose to go about it in a particular manner. He also was her opponent. He's now the governor of Georgia. His office purged more than 1.4 million voters from the rolls since 2010, including more than 600,000 Georgians in the year 2017, and then another 90,000 that were not purged in 2017 in a cleanup act in 2018. Many of those voter registrations were canceled because the voter had not voted in the previous election. Georgia also closed a tenth of its polling places since 2012, with the majority of closings occurring in poor counties and those with significant African-American populations. Georgia also enacted a, quote, exact match, unquote, law that resulted in 53,000 more voters being given only pending status on their voter registrations because of minor errors on their registration forms, with more than 70% of those voters being African-American. This is exactly the kind of attrition on voting rights that preclearance would have stopped from going into effect. Before the Voting Rights Act, the state of voting rights in the Deep South was abysmal. In the mid-50s, only 1 in 4 African-American voters in the South was registered. With its robust preclearance requirement, the act had dramatic positive effect on black voting registration in the South, which increased to 62% just 3 years after the act became law. Yet these gains and others are at risk because of the Shelby decision. The Supreme Court was wrong, in my opinion, to undermine the Voting Rights Act. Congress failed to act the last time we had a chance to do it. Hopefully we won't fail again. Congress must now respond. It's imperative that we restore the Voting Rights Act preclearance requirement so as to stay true to the Act's purpose of ensuring equal voting rights for all. John Lewis and many others risked their lives. John Lewis was beaten in the head marching for voting rights in Selma, Alabama. Others were killed in Selma and other places in the South looking for voting rights. Voting rights are so important, and we can't let those people's deaths, those people's injuries, and those people's efforts go for naught. I thank our witnesses for being here and look forward to their testimony. I now yield for the opening statement from the ranking member, the honorable gentleman from Louisiana, Mr. Johnson.